Okay, I owe you guys an explanation of what is going on with the motion to compel regarding Kaysen Kozlow, a current TAG employee and a former TAG employee, about documents related to conversations they had during, I believe, as far back as August of 2024 and then December 2024 through March of 2025. I wanted to be really careful about talking about this because, in part, there has been someone who has left comments on my account claiming to be one of these people. And I want to make it very clear that I don't know these people. I've never talked to these people. I've never messaged with these people. I wouldn't do that. So, I don't have any inside knowledge here. And I'm not, I'm not going to give legal advice to anybody, but I would say if any of those people are actually lurking around, please be careful what you say on social media. But I do think that the issues are interesting and worth talking about because it is getting to something that has been sort of hovering over the case from the beginning. Which is, was this sort of a grand conspiracy, or was it like a group smear campaign, or was this group therapy, right? Was everybody talking to each other because they were all involved in the same bad acts, or was everybody talking to each other because they were all like, holy fuck, what are we going to do about this? So what is essentially going on is, during the course of discovery, a whole bunch of documents, it looks like hundreds of them, have been identified as messages between either Case, Kozlow, and a whole slew of others regarding things that are relevant to this case. So there's other TAG employees like Abel and Nathan. There's Brian Friedman, other people in his firm, Mitra, who is another lawyer in another firm, Wayfarer, and potentially even Case's dad. And some of them include Jed Wallace. And so these have been identified, but Case and Kozlow have said these documents were not turning over because they are subject to one or more privileges, right? These are privileged conversations, and we therefore do not have to turn them over. And they have provided privilege logs, which is what you do. They've updated them a couple of times to say, here's what exists, here's what it's about, and here's why we think it's privileged. Okay, so this is part of their privilege log. So when you are saying, yes, there are documents that are responsive to your request for documents, but I'm not going to give them to you because they're privileged, you can't just say, sorry, there's documents, but you can't have them. You basically have to give as much information as you possibly can without turning over the actual protected information. So you have to say, what's the date of the document? Why are you holding it back? Who's it by, between, and among? What's it about? And so they have gone through and done that with, it looks like, hundreds and hundreds of documents. And they all say some version of this is privileged and or this is work product, which are the two main ways that you can withhold information if they are relevant to conversations with attorneys or active or in anticipation of litigation. So what makes this particular situation complicated is that they don't all have the same lawyer, and they're not necessarily all anticipating the same litigation, right? So there's no question that, see, Catherine Case up there is talking to James Case. James Case is Catherine Case's father, who is a lawyer. So she's like, I was getting my legal information and advice from my father, right? That is different than Kozlow and Nathan in the third one talking to Brian Friedman and Summer Benson from Brian Friedman's firm, right? So they're saying each of these conversations individually were privileged and or work product, even though we were talking to different lawyers, sometimes at different times. And the argument that they're making is that even though they were different combinations of people talking to different lawyers about different things and different times, they all had a common interest. And the common interest is figuring out what the fuck to do about Blake Lively, essentially. And so what they're trying to do is string together multiple conversations and multiple different interests for reaching out to lawyers to say, even though we were reaching out to different lawyers at different times, asking for different advice, and we were talking to PR people about some things and legal people about other things, they were all part and parcel of the same idea, which is trying to figure out how to deal with the claims that Blake Lively was going to make, and ultimately, once we get to 2024 December, the claims she ultimately did make. Now, what's interesting about this is it actually is the flip side of the conspiracy argument that Blake Lively has been making the whole time. She claims that all these people were engaged in a conspiracy against her. That is one of her claims in her complaint. And so they're saying, like, yeah, we were all working together. We were all talking to each other. By claiming the common interest privilege, they are saying, yes, we all had a common interest in trying to deal with what you were putting out there, what you were saying you were going to put out there, and then ultimately defending not only the legal claim, but the PR problems that came out of the New York Times article. So they don't necessarily disagree on the fact that all of these people were working together. What they disagree on is whether the law protects the communications about it because of who was involved. So Lively's main argument is, even assuming that, reaching out to Brian Friedman in August and Catherine talking to her dad in August, and even assuming all of that can be swept into the same privileges and the same work product, Jed Wallace ruins it for everybody. Because at no point was Jed Wallace legally represented by any of these people. And so when you included Jed Wallace in conversations, you destroyed the privilege. And this is sort of a baseline privilege argument that they teach you in law school, which is, if you are in a conversation, whether written or oral, and there's someone in the room who is not the client, you waive the privilege by letting that person listen to the conversation, right? So if I go in to talk to my lawyer and I bring my friend with me and I'm like, hey, just sit there, we're going to lunch after, just sit there while we have this conversation. I and my lawyer are talking about privileged information in front of somebody who's not in the privilege. So later, someone can call her and she can tell people everything that we said, because we've waived the privilege by having someone who is neither the lawyer nor the client in the conversation. And what they are claiming, what Lively is claiming, is Jed Wallace being in this conversation blows up the privilege. By talking about all of this in front of Jed, they essentially waived all of these protections that they're now trying to assert. They will not let me make myself any smaller than this today. I don't know why. So Lively's saying, like, Jed blows it all up. And then they've made a couple of other arguments, like, conversations between Case and her dad are not necessarily privileged just because her dad happens to be a lawyer, and it seems like they've actually got at least some evidence of her hiring him. And we do that all the time. Lawyers do that all the time. We'll be like, hey, I'm going to buy you lunch next week. Okay, so I'm hiring you. Okay, all right, so here's the privilege. So the judge is probably not going to break through that. This issue of former employees, that's silly. If you were within the privilege at the time that the communication was made, if you were the client at the time the communication was made, and you have later conversations that relate back to that, like with former employees, that's still within the privilege. That's silly. That happens in litigation all the time. People make decisions, they leave, and then you, as the lawyer for the organization they have left, can still talk to them within the privilege about the things they did back in the day. What the Case and Koslow, or what the Lively people said is, well, we should have an in-camera review. And that means let the judge see it all and decide what is and isn't privileged. And the Case and Koslow people are fighting that pretty hard. They don't want an in-camera review, which tells me that there's something in there. I think if the Lively people are pushing in-camera review this hard, that means they think that if the judge sees something, he'll be like, oh, well, that's got to be in this case, because obviously this is relevant and it either helps or hurts some party. But there's an even more, I think I believe that even more in this case, because there's conversations in these letters that when Case and Koslow's lawyers turned these over, at some point when the Lively lawyers were looking through them, they realized stuff had been turned over that wasn't supposed to be, like, oh, you accidentally gave me privileged information. And they did what they were supposed to do, which is you call them and say, hey, you gave us privilege, we're going to send it back, we're going to destroy it, that was an accident. I wonder if the Lively people saw something in there and they know it's there, but now they can't have it. So they want the judge to see it. But this is probably a legal question that the judge is going to have to answer as to whether and to what degree these privileges apply, and whether this common interest privilege can circle up